So we know from our first 4 lectures that a bare promise not supported by consideration is not an agreement for the purposes of the Indian Contract Act. And if it is not an agreement for the purposes of the Indian Contract Act, it cannot be obviously enforceable by law, because a contract is an agreement enforceable by law. Therefore, if you have no agreement, there is nothing to enforce. And if you have nothing to enforce, you have no contract. Every day, right, we make quote-unquote agreements, and I use this word agreements in the loose, non-technical, non-legal, non-Indian Contract Act sense. Okay, so I've used the analogy. I say, Dad, will you cook for me? Dad will say, okay, I'll cook dinner for you. Arjun Tendulkar says, hey, President of the BCCI, will you pick me in the under-19 team? He says, of course I'll pick you in the under-19 team. You know who you are. Of course I'll pick you in the under-19 team. Okay, the poor kid, he's going to have to face this scrutiny for the rest of his life, but he better get used to it. Anyway, that apart, what is the problem with those 2 analogies? I've given you these analogies repeatedly, and if you still haven't picked them up by the time of this lecture, which is what, lecture 5 of this course basically, I think you're lost. So you better start again and go watch the earlier lectures. What's missing? Consideration. There has to be some benefit or a detriment to a particular party. When my dad says, oh son, you want me to cook dinner for you? Okay, I'll cook dinner for you. Yes, there's a benefit to me. There is a benefit to me. Is there a benefit to my father for cooking? Not really. Okay, there's no real benefit to my father. You say, sir, but there is a detriment, right? What is the detriment that my father is facing? Well, you could say that the detriment is he now has to cook. Okay, good point. This is why the flaws or the limitations of this benefit detriment exercise get exposed. Consideration is much more than just benefit or detriment. And section 2D of the Indian Contract Act very consciously avoids the use of the word benefit or detriment. They simply say act. They say an act at the desire of the promiser, carried out by the promisee. Basically, an act or even an abstinence, an act or an omission, or an act or a refraining from doing a particular act, basically can constitute consideration. So in that example, my dad will say, okay, son, I will cook dinner for you, provided, son, that you wake up every morning at 6 a.m. He's asking me to do something there. So he's asking me to perform an act. Okay, he's saying if you wake up at 6 a.m. every morning, I will cook breakfast for you, let us say. Okay, you wake up every morning at 6 a.m., I will cook breakfast for you. Okay, so he's asking me to perform an act. It's at the desire of my father. He is the promisor because he is making a proposal. I will cook dinner for you if you wake up at 6. I beg your pardon, I'll cook breakfast for you if you wake up at 6 a.m. is what my father is saying to me. I say, yes, I'll wake up at 6 a.m., you cook dinner for me, offer acceptance, communication of acceptance from both parties, basically, right? Vice versa, essentially, all right? So, it's not a bare promise. It's not a mere nudum pactum, a bare promise, a promise that really amounts to nothing on behalf of my father. The benefit to him is he gets to see his son wake up at 6 a.m., lead a healthy life, stay disciplined. The benefit to me is my father cooks breakfast for me every morning. So do we have consideration? Is that an agreement? Is that agreement enforceable by law? Right? Let's rewind the clock. Let's go back to section 2D, which is now on your screen, and the answer will become clear. Section 2D. When, at the desire of the promiser, the promisee, or any other person, I want you to keep that any other person in mind, okay? Keep that any other person in mind, all right? We're going to come to that shortly. Where the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. In our analogies, it's very, very apparent that there is consideration. So Arjun's promise to call off negotiations with the England and Wales Cricket Board is consideration for the BCCI's promise to pick him for the under-19 team, and vice versa, i.e. the BCCI's promise to pick Arjun for the under-19 team is consideration for Arjun's promise to call off negotiations with the ECB. Ladies and gentlemen, we have done this analogy to death. Go back to the very first lecture of this course, and I have dealt exclusively with this analogy in that lecture. Arjun and the BCCI have therefore entered into an agreement as, and this is the key part, right? This is the definition of an agreement in the interpretation clause section 2. Every promise and every set of promises forming the consideration for each other is an agreement. So there is no mere nudum pactum, there is no bare promise, there are promises on behalf of both parties. Each promise forms the consideration for the other, okay? Therefore, every promise and every set of promises forming the consideration for each other is an agreement. Section 2H says an agreement enforceable by law is a contract. Clear enough? Pause it, read it if you have to. I don't really think you do. Next slide and next case, or should I say the first case of this all-important lecture on consideration, Doraiswamy Iyer versus Arunachala Iyer. What happened in that case? Let's read the facts. This civil revision petition, hey, you should know what a civil revision petition is. If you don't, go look at our lectures on the CPC. This civil revision petition arises out of a suit in which the trustees of a temple sought to recover a contribution promised by a subscriber to a subscription list for the repairs of a temple. It appears upon the facts found in the lower court that the plaintiffs, the present respondents, the trustees, entered into a contract for the necessary repairs in the month of February 1928, and the masonry of the contractor was supplied with money from village common funds. Interesting. As the work proceeded, more money was required, and to raise this money, subscriptions were invited and a subscription list raised. This was in October. The present petitioner put himself down in the list for rupees 125, and it is to recover this sum that the suit was filed. Therefore, the plaintiff contends, right, that the consideration for this promise is as follows: that the plaintiffs, relying on the promise of the subscriber, incurred liabilities in repairing the temple. The question is, does this amount to a consideration? So, ladies and gentlemen, I am back on screen. What happened in this case? Very straightforward stuff. Basically, a temple needed repairs. Okay, the trustees of the temple undertook those repairs. They entered into a contract to undertake those repairs. There's a separate contract from the contract with the plaintiff in this case, with Doraiswamy Iyer. Okay, the trustees represented by Arunachala Iyer entered into a contract with the contractor. Now you know where that term comes from, right? Building contractor. Okay, contractor entered into a separate contract with them for repairs to the temple. Now to fund that contract, they've entered into it basically. All right, the repairs have commenced. The Mestri, the supervisor, has commenced the work. They invite subscriptions. They say, what is this? A very old term. Okay, the word subscription today is associated with Hotstar or Amazon Prime or Netflix. No, but in the olden days, you subscribed, yes, of course, to a magazine, but you also subscribed to a list. You made a donation to the temple so that they can carry out whatever repairs or whatever they needed to do, whether they needed to feed the, the poor and the needy and what have you, basically. So what happens? The temple invites subscriptions in October of 1928, a full 7 to 8 months after the works have commenced in February 1928. The plaintiff, in that case, is the trustee, right? He receives a subscription basically from the defendant in the case, Doraiswamy Iyer. Doraiswamy Iyer says, hey, put me down for 125 rupees. I would like to donate 125 rupees. Now you say, sir, they really instituted a suit for 125 rupees? My dear students, this is a case from a long time ago. It's a case from almost 90 years ago. Was it 90s, 80 years ago? Basically, so 125 rupees 80 years ago was a lot of money. So the trustees go to court, they file a plaint, and they formulate the consideration in that case as follows. Let's just go back to the slide. It's on your screen. The plaintiff finds the consideration of this promise as follows: that plaintiffs, relying on the promise of the subscriber, incurred liabilities in repairing the temple. The question is, does this amount to a consideration? What do you think? Come on, what do you think? No, why not? The definition, and we're now on the next slide. The definition of consideration in the Contract Act is that where, at the desire of the promisor, the promisee has done or abstained from doing something, such act or absence is called consideration. We know this. Therefore, the definition postulates that the promisee must have acted on something amount to more than a bare promise, a mere nudum pactum. There must be some bargain, and therein lies the nub, basically, right? That is, right, the key word. There must be some bargain between them. You can bargain between a father and a mother can bargain with their child. There must be some bargain between them. Doesn't necessarily have to be a commercial bargain, in respect of which the consideration has been given. I think, and this is the key part from the judgment of the British judge, Justice Cornish, it cannot now be accepted that the mere promise to subscribe a sum of money or the entry of such promised sum in a subscription list furnishes consideration. There must have been some request by the promisor to the promisee to do something in consideration of the promised subscription. This is a mere act of charity. In the present case, it is not pleaded, nor is there evidence that there was any request by the subscriber when he put his name in the list for 125 rupees to the plaintiff to do the temple repairs, or that there was any undertaking by them to do anything. In my opinion, this was a mere nudum pactum, a bare promise unsupported by consideration, and the suit ought to have been dismissed at the court of first instance. This suit should never have come to the Madras High Court. So, ladies and gents, it's straightforward. I'm back on screen. Where is the consideration? When you say to the trustees, basically, here is 125 rupees for the temple. Okay, you give it to them. They say, thank you very much. Right? We call it a hundi, right? In the south at least, we call it hundi. We go and put the money in the box. They keep a box in the temple. Those of you who are Hindus know what I'm talking about, basically, right? Or those of you who are not Hindus, if you're Christians, you're Muslims, you know, giving alms, as they say, right? People sitting outside the mosque, for example, you give them money. You know, the person is sitting outside the mosque, basically, and you know, she's asking for alms, and you say, you know, I will come back tomorrow and I will give you 20 rupees. I'll come back tomorrow, give you 30 rupees. She says, thank you very much. Is there consideration? No, it's a mere nudum pactum. It's a mere act of kindness, an act of charity, basically. The situation would have been different if the trustees had entered into the contract with the contractor on the basis of the promise made by the defendant in that case, Doraiswamy Iyer, saying, Doraiswamy Iyer says, here is 125 rupees, go ahead and make the repairs. So you say, sir, but here again, isn't that an act of charity? It might be, but it becomes a promise supported by consideration the moment the trustees enter into a contract with the contractors to undertake repairs. What have they done? They've incurred liabilities. That did not happen in this case. The work commenced in February 1928. They've already incurred liabilities. Okay, the plaintiff, basically, right, simply subscribed and he said, here is 125 rupees. He didn't hand it over. That is why there was the suit. He simply put his name in the list and said that he would give 125 rupees. There was no request made at the instance of the trustees of the temple. It could very well have been made. But notice the words that Justice Cornish uses in that judgment, right? Let's just go back to that. He says, it is not pleaded, nor is there evidence that there was any request by the subscriber when he put his name in the list for rupees 125 to the plaintiffs to do the temple repairs, or that there was any undertaking by them to do anything. It was a mere act of charity. He said, here's 125 rupees. They said, thank you for your 125 rupees. See, there is no pleading that there was a promise made, or basically, or an act was undertaken, or the money was given at the desire of the promisor, basically, or in this case, either party could be the promisor or the promisee. In this case, the plaintiff is claiming that the promisor was the defendant. By putting his name down, he became a promisor. No, he didn't, because his promise was not supported by consideration and therefore he didn't enter into any agreement. He did not say, here is 125 rupees for temple repairs. There was no act at the desire of the promisor. The act here was not at the desire of the promisor. The act here was undertaking repairs, which act had commenced well before the plaintiff, right, had basically brought this suit, and in fact well before the plaintiff made the request for subscriptions. And simply by entering his name in the list, there was no consideration, a bare promise unsupported by consideration, as Justice Cornish put it. And so I'm moving on now to the next slide. The key consideration, no pun intended, is that it must flow, i.e. the consideration must flow from the promisee or any other person. Okay, now we introduce this element of any other person. Who is this any other person? Let's read the facts in Balamba v. Krishnaiah, the Madras High Court decision from 105 years ago. All right, and all will become clear. It was held in Chinnaya Rao versus Ramaya, 1882 Madras HC, that a third person who was not a party to a contract, could sue the promisor, though the consideration proceeded from the third person's stepmother and not from the third person himself. Justice Innes held that the consideration moved indirectly from the third person, and hence the third person himself became a promisee under the Contract Act. Okay, let's just continue. There was an ancient English case from 130 years ago, Dutton and Poole. All right, now in Dutton and Poole, what happened? A son made a promise to his father that in return for his father not selling a piece of wood, he would pay £1,000 to his sister. Okay, I'm sorry, it's not a piece of wood, it's a wood, it's ancient English usage. Okay, don't worry about what a wood is. Okay, so a son made a promise to his father that in return for his father not selling a wood, he would pay £1,000 to his sister. The father refrained from selling the wood, but the son did not pay. Aha! It was held that the sister could sue on the ground that the consideration and promise to the father may well have extended to her on account of the tie of blood between them. There was some disagreement in argument on the grounds that the daughter was privy neither to the promise nor the consideration. Very, very interesting. I'm back on screen. So let's bring my mother into the mix here. Okay, so the analogy is this. I say, Father, will you cook dinner for me? Father says to me, son, I will cook dinner for you if you take your mother to the supermarket. Okay, and when you take her to the supermarket, I want you to buy her any groceries that she needs. Interesting. Okay, so father says, here is my proposal. I will cook dinner for you if you take your mother to the supermarket. You say, okay, father, cook dinner for me, and then tomorrow I will take my mother to the supermarket, or let us make that a mall. I'll take my mother to the mall, I'll take her shopping, and I'll buy her any clothes that she wants. Okay, counter offer. Father says, okay, great, I accept. So here we go, I'm going to cook dinner for you. Father cooks dinner. He's part of the consideration. His part of the consideration is executed. Remember that word. We're coming back to that later in this lecture. So his part of the consideration is executed. My part of the consideration remains executory. What is my part of the consideration? Because my father has cooked dinner for me, I now have to keep up my end of the bargain, and I have to take my mother to the mall, take her shopping so that she can buy whatever clothes she needs or whatever clothes she wants, basically. Can my mother sue me for breach of contract? Can she file a plaint? All right, her cause of action being breach of contract, that I have breached the contract. Has the consideration moved from the promisee, or has it moved from any other person, basically? Or has the consideration moved from the promisor or any other person, right? Essentially, there are three parties involved here. So the question is, what are the rights of my mother? Let's go back to the judgment. In the case, it's on your screen. What does Justice Iyer say? He says that under Section 2D of the Contract Act, the consideration need not flow from the promisee, and hence even a third person could sue as a promisee, though no consideration flowed from him. So I am the promisee in this situation? No, I am the promisor. I make an offer to my father. I make a proposal to my father. I say to my father, if you cook dinner for me tonight, I will take mother to the shopping mall tomorrow and buy her whatever clothes she wants. Father accepts and he says, I will cook dinner. Basically, father is the promisee. By cooking dinner, father is the promisee. His half of the consideration now stands executed. Can my mother sue as the promisee, even though no consideration flowed from her? Under clause D, and this is what Pollock and Mullah, right, authoritative treatise on the subject says, though under clause D, the consideration may move from the promisee or any other person, under clauses A, B, and C, no man could be called a promisee, and no man could therefore become entitled to bring a suit as a promisee unless he has accepted the proposal of the promisor, and thus comes under the definition of the promisee in Section 2C. In this case, right, this is the case of Balamba and Krishnaya. The wife and children were not asked by the promisor whether they assented to the proposal to benefit them, and they did not accept any such proposal, and hence cannot come under the Contract Act definition of promisee. So also in Chinnaya Rao v. Ramaya, the beneficiary under the agreement was not a party to the agreement, as he had not accepted any proposal, and hence cannot be called a promisee under the Contract Act. I am inclined to agree with the criticisms of Pollock and Mullah. Justice Iyer. Guys, do not fret. I am going to explain this back on screen. Very, very straightforward stuff, guys. In this case, I am the promisor. I say, father, will you cook dinner for me tonight? If you cook dinner for me tonight, I will take mother to the shopping mall tomorrow and buy her whatever clothes she needs. Okay. So, father accepts. Okay. My mother is present when my father and I are having this conversation. My mother is present when I am making this proposal as the promisor, and my mother is present when my father accepts this proposal as the promisee. He is performing the act of consideration here. He is cooking dinner, but he says to my mother, is this agreeable to you? She says, yes, this is agreeable to me. Go ahead, husband, cook dinner for our beloved son tonight, and tomorrow, basically, right, he will take me to the shopping mall and buy me whatever clothes I want. Very good. So, what do we have here? Basically, we have a contract that is concluded between myself and, for all intents and purposes, my mother, because the contract entered into between myself and my father is for the benefit of my mother. The mother is the beneficiary under the contract. She was privy to the discussions between my father and I, and my mother has assented to the proposal made by yours truly. Okay, so that means the consideration may flow from the promisee or any other person, right? The construction the courts have given to it over the years is that the promisee must essentially be a privy, or must be privy rather, should I put it grammatically correctly? The promisee must be privy to the contract. There must be privity of contract. Remember that an analogy I used a couple of lectures ago. I said, we have question hour in Parliament. Rajnath Singh is the Home Minister. He stands up. They ask him a question about, let us say, the lynchings, basically. Sure. Right, on the issue of lynching, he is the Home Minister. He is responsible for law and order, right, of the union, basically, and he is responsible for coordinating between the union and states. Law and order is a state subject, but it is essentially, right, subject to the overall superintendence of the Home Ministry, because it is the Home Ministry, right, that is the umbrella organization of law enforcement in India, basically. So Rajnath Singh stands up and he answers questions. Then the next question put to Rajnath Singh is, Rajnath Singh ji, can you answer a question on GST? Rajnath Singh says, I cannot answer this question on GST because first of all, I'm not the Home Minister and I am not privy, P-R-I-V-Y, I'm not privy to the discussions that have taken place on this subject between Arun Jaitley, the Finance Minister, and the Prime Minister Narendra Modi. So he's not privy to those discussions. Was my mother privy to the contract entered into between my father and I? Yes, she was. If she was in the room and she assented to the proposal, she agreed that she would be the beneficiary under this contract, and with her assent, with her being privy to those discussions, there was privity of contract between my mother and myself. I hope that's clear. This is known as the privity of contract rule. A stranger to a contract cannot sue under that contract, basically, or under a particular contract. A stranger to a particular contract has no cause of action, basically, accruing under that contract. Only parties to the contract, only those who are privy to the contract may sue. This is known as the doctrine of privity of contract, which you will now delve into. It's on your screen. Privity of contract. This is a perfectly plain case. The action is brought by a mortgagee to enforce against a purchaser of the mortgaged property, an undertaking that he entered into with his vendor. The mortgagee has no right to avail himself of that. He was no party to the sale. The purchaser entered into no contract with him, and the purchaser is not personally bound to pay this mortgage debt. Beg your pardon. Therefore, he is not a person from whom the balance is legally recoverable. Their lordships will therefore humbly advise His Majesty that this appeal must be dismissed with costs. Jamna Das versus Pandit Ram Avtar Pandey, 1911, Judicial Committee of the Privy Council, the highest appellate body of British India, basically, the highest appellate court in British India. What is the annotation I put there? The Privy Council extended the rule in Tweddle and Atkinson. Tweddle and Atkinson, that the consideration must flow from the promisee to the promisor, and they extended this to India. Some could say, right, in disregard of the statutory provisions and the interpretation clause in section 2D. Don't fret. Simply put, what this means is simply that my mother is not a stranger to the contract. She is considered a promisee. So don't fret. Yes, consideration may move from the promisee or any other person, but the words any other person have been given a restricted meaning. So it cannot mean any stranger to a contract, but the courts have construed that to mean promisee, yes, and any other person who is privy to the contract. So that any other person must be privy to the contract. So the privity of contract basically has been brought in through the back door. Academics have written about this. Academics have written about how privity of contract, basically, that doctrine has now been introduced into India's Contract Act jurisprudence through the back door, although the drafters did not particularly care for it. Therefore, on a strict literal construction of the text of that provision, the consideration need not move from the promisee, it may move from any other person, basically. But that is not the law today. They've given it a more, I don't know whether to call it a purposive interpretation, but the interpretation they've given it is that any other person cannot be a stranger. It has to be read to mean that any other person has to be read to mean somebody who was privy to the contract, basically. So you say, sir, does that mean now I execute a mortgage? I am the mortgagor, basically. Okay, I have a house. Let's say I have a flat in Trump Towers in Pune. Okay, so I have a flat in Trump Towers in Pune. I want to buy the flat. So I want a housing loan. So how do I get a housing loan from, let us say, HDFC? I have to execute a mortgage in their favor. They will give me the purchase price, right? So maybe I put down 1/3 of the purchase price from my savings. They give me a mortgage for 2/3 of the purchase price. I execute a mortgage in their favor. I create a charge on the flat, which is immovable property. So when you create a charge on immovable property, in this instance, it becomes a mortgage. Okay, HDFC is the mortgagee, I am the mortgagor. The mortgagor basically has something known as the equity of redemption. The mortgagor can sell the property, can realize the sales from the property only when basically he has discharged his obligation to the bank. His obligation to the bank is what? A housing loan that he has taken to basically buy the property. The moment he pays back that loan, principal plus interest, he is discharged from the mortgage. Basically, there's equity of redemption. He can basically, in that scenario, right, have that charge basically removed. Okay, I'm not using very technical terms. We'll deal with this in detail in property law part 2. So what happens in that scenario? You have a mortgage, you have a charge on the property. Therefore, you cannot sell that property, right, without the consent of the bank. So you might say to the bank, HDFC, that whoever, you know, your bank manager or whoever has been allocated to handle your case, that I cannot keep up the principal and interest payments on this loan. I would like to sell this property, and from the proceeds of that sale, I would like to repay the loan. The bank can consent. But what happens in a scenario like that? Basically, the bank has a charge. So if you sell the property to a third person without the consent of the bank, right, can the bank go after that third person, in this case, the purchaser? Did they enter into a contract with that purchaser? No. Is there a privity of contract between the purchaser of the mortgage property and the bank? No. There is privity of contract between you, the mortgagor, and the mortgagee. So the mortgagee can proceed against you, the mortgagor, right, in personam, basically. Okay, he proceeds against you in personam. So you say, sir, what happens? There is a charge on that property. So there's all this these provisions about the duties of the buyer and the seller, right? The duties of the buyer of a property to basically carry out a check on the title deeds, on the title of the property. That charge would have been registered by the bank. Therefore, when checking the land records, that charge should have come up. Buyer beware and all of that. Basically, we're going to deal with that in property law part 2. But there is no action in law. There is no action that is under breach of contract. Okay, there is no action under breach of contract. They cannot proceed against the purchaser because there is no breach of contract. There might be a breach of the mortgage deed, but that breach has been committed by the mortgagor against the mortgagee. The purchaser is a purchaser. Let us assume he's a bona fide purchaser without notice of the mortgage. So all of this gets complicated and we go into property law. I don't want to do that. Go look at our lectures on property law part 1, and part 2 will be up around, you know, towards the end of 2018. So go have a look if you're watching these lectures in 2019. All of that will become clear. At this point, I just want to say the bank cannot proceed against that purchaser, right, under the Contract Act, because there is no privity of contract. He has an action in equity, and this is what the courts have sought to clarify, right, in the case, and that case is on your screen now, right? Nawab Khwaja versus Nawab Hussaini Begum, basically, as well, that there are certain exceptions to the privity of contract rule. So this privity of contract rule will not be strictly enforced. Okay. So what happened in that case? The suit which has given rise to this appeal was brought by the plaintiff, a Mohammedan lady, against the defendant, her father-in-law. So Mohammedan lady has brought the suit, basically. Okay. And the suit is against her father-in-law, the defendant, to recover arrears of a certain allowance called a kharche pandan under the terms of an agreement executed by him on 25th October 1877, another ancient case, prior to and in consideration of a marriage with his son Rustam Ali Khan, both she and her future husband being minors at that time. Okay, interesting. The agreement in question recites that the marriage was fixed for the 2nd of November 1877, and that therefore the defendant declared of his own free will and accord that he shall continue to pay rupees 500 a month in perpetuity to the plaintiff for a betel leaf expenses, that's kharche pandan. Okay, basically a monthly allowance of 500 in perpetuity from the date of the marriage, that is from the date of a reception, marriage reception, out of the income of certain properties therein specifically described, which he then proceeded to charge for the payment of the allowance, basically. So he executed a charge on those properties. The husband and wife lived together until 1896, when owing to differences, she left her husband's home. Okay, so the question, the key question is, was there privity of contract between the Mohammedan lady Hussaini Begum and her father-in-law Nawab Khwaja? That is the question. Well, let's go to the judgment of Justice Ali. It's on your screen. Beneficiary under the contract. First, it is contended on the authority of Tweddle and Atkinson that as the plaintiff, all right, was no party to the agreement, she cannot take advantage of its provisions. Okay, so the contention is no privity of contract, cannot take advantage of the agreement. Remember that she was a minor, her husband was a minor. The agreement was executed between, right, two parties, majors, for the benefit of their minor children. Both were minors, remember that. Okay, we're coming to capacity to contract in the next lecture. Don't get bogged down with that. With reference to this, it is enough to say that the rule, all right, that the rule of common law, privity, on the basis of which it was dismissed, is not in their lordship's opinion applicable to the facts and circumstances of the present case. Here the agreement executed by the defendant specifically charges immovable property for the allowance which he binds himself, acknowledgement, estoppel are also exceptions to the privity rule, to pay to the plaintiff, and she is the only person beneficially entitled under it. In their lordship's judgment, although not a party to the document, she is clearly entitled to proceed in equity to enforce her claim. Okay. The lordships desire to observe that in India and among communities circumstanced as the Mohammedans, among whom marriages are contracted for minors by parents and guardians, it might occasion serious injustice if the common law doctrine of privity of contract was applied to agreements or arrangements entered into in connection with such contracts. Okay, so very, very interesting. I'm back on screen. There is a certain harshness associated with the privity of contract rule, and this harshness was in full display in the Karche Pandan case, basically, where the Begum was not a party to the agreement. It was an agreement executed between her guardian and the guardian of her husband. The guardian of her husband in that case was the defendant, right, basically. And he said, yes, let's contract the marriage of our two children. I will create a charge on the immovable property, and because and I will do that because I've agreed to pay 500 rupees a month as allowance. 500 rupees a month in 1877 is a huge amount. These were very affluent Mohammedans, basically. So what he does, he then breaches that agreement that he entered into with the guardian of the Begum. He does not pay the 500 rupees. And the Begum then brings a suit because now the marriage has basically the marriage has gone down the drain, they're separating, but she says that I want that 500 rupees a month in perpetuity, basically. Okay, what did the court say? Yes, under the strict terms of the common law, under the privity of contract rule, right, and that common law rule of privity of contract has now been incorporated into the Indian Contract Act by judicial interpretation, mind you, that no stranger to a contract, that any other person cannot be a stranger to the contract. What happens? Basically, she has no right to sue. Therefore, what did the courts do? The Privy Council, the highest appellate body in the United Kingdom, I beg your pardon, the Privy Council, the highest appellate body of the dominions and the colonies, basically, they said Mohammedans are circumstanced in such a manner that they often contract marriages for their minor children, right? So if the children are beneficiaries under that contract, they can enforce that claim in equity, but the privity of contract rule stands. So they mitigated the harshness of the privity of contract rule by saying they can enforce their claim in equity. The big headline is the privity of contract rule has been affirmed repeatedly. Okay, and let's go to a quote, okay, to really bring this home. It's on your screen. Under the English common law, only a person who is party to a contract can sue on it, and that the law knows nothing of a right gained by a third party arising out of a contract. Okay, that's the rule in Dunlop Pneumatic Tire and Selfridge. It has, however, been recognized, and this is the Supreme Court in Chaco v. State Bank of Travancore. Okay, Travancore, the erstwhile was the erstwhile name for Trivandrum. It has, however, been recognized that where a trust, all right, where a trust is created by a contract, a beneficiary may enforce the rights which the trust so created has given him. The basis of that rule is that though he is not a party to the contract, his rights are equitable and not contractual. The basis of the rule is that a stranger to the contract, who is a beneficiary under that contract, can enforce those rights in equity and not in contract, or not under the Contract Act. The Judicial Committee applied that rule to an Indian case, Khwaja Muhammad Khan versus Hussaini Begum, which we have just considered. In a later case, Jamandas v. Ram Avatar, again the mortgage case, the Judicial Committee pointed out that the purchaser's contract to pay off a mortgage debt could not be enforced by the mortgagee who was not a party to the contract. It must therefore be taken as well settled that except in the case of a beneficiary under a trust created by a contract, or in the case of a family arrangement, a family settlement deed which we have alluded to in property law. Go watch my property law Law Part 1 lectures. Also watch the lectures on family law, which hopefully will be up by the end of 2018. No right may be enforced by a person who is not a party to a contract unless he is a beneficiary under a trust or is a beneficiary or a member or a party to a family settlement. Basically, the rule therefore has been reiterated by the Supreme Court in Chaco versus Trade Bank and Travancore 50 years ago. All right, guys, now I'm quickly moving on to the next slide. It's on your screen. The next topic: what is the meaning of has done or abstained from doing? It's on your screen. Past consideration is good consideration. Hussain Ali Kasam, Vidinbai, 1923, Bombay HC. I want you to remember this line like your life depends on it. Past consideration is good consideration in India. Past consideration is good consideration in India. Say it with me. Consideration is defined in Section 2D of the Indian Contract Act. We know that when at the desire of the promisor, the promisee or any other person has done or abstained from doing such act or abstention or promise is called a consideration for the promise. So has done or abstained from doing. Does this mean that you may be compensated for an act that you have done without being requested to carry out that act by the promisor? That is what Hussain Ali Kasam and Dinbai dealt with. Something, okay, and I'm quoting from the judgment, which the promisee has done, all right, something which the promisee has done at the desire of the promisor before the promise is given is good consideration. It is therefore not necessary to consider whether at the time that something was done by the promisee at the desire of the promisor, it was intended that recompense was to be given, the amount to be fixed at a future date, although as stated in the leading treatise on Indian contract law, Pollock and Muller, 4th edition, page 26, in many common circumstances, and pay close attention, the fact of service being rendered on request is ample evidence of an undertaking that it was to be paid for according to the usual course. There can be no difference whether A says to B, I will give you rupees 1,000 a month if you live with me for a year, or I will give you rupees 1,200 because you have lived with me for a year. The something to be done by the promisee in the one case is the same as the something to be done in the other case. Pause this and read it. If you understand this slide, you have understood Section 2D and you have understood what is past consideration basically. Arjun goes to the BCCI. Hey, pick me in the under-19 team. BCCI says, okay, we've picked you in the under-19 team. Arjun then says, you've picked me in the under-19 team. I will now call off negotiations with the ECB. Who is the promisor here? Arjun. Who's making the promise? Arjun. I will call off negotiations with the ECB. Who is the promisee? The BCCI. Has their consideration been executed? Have they carried out their bargain, their part of the bargain? You say, sir, there was no bargain. Arjun simply went and said, pick me in the under-19 team. They picked him. There's no promise, it's just a request. They've acceded to his request. But what has Arjun done? After they've picked him in the under-19 team, he's gone to them and said, you've picked me in the under-19 team. I will now call off negotiations with the ECB. Arjun has made a promise. Arjun has become the promisor. And what is the consideration for Arjun's promise? It is past consideration. It is executed consideration. There is a difference between past and executed consideration. Okay, it's a very nuanced difference. Executed consideration, right, and past consideration basically are different like this. Let me explain. There are three types of consideration. You have past, you have executory, you have executed. You order, basically, let us say, a smartphone from Amazon Prime. You have contracted with Amazon, you have paid them 30,000 rupees. Okay, is your consideration executed? Yes, your half of the bargain, your promise has been completed. You entered into a contract to buy a smartphone for 30,000 rupees. You paid that 30,000 rupees by a debit card. Now, the consideration on your side is executed. Amazon basically has to execute their half of the consideration or their part of the bargain. So Amazon delivering the phone to you in a fit state, basically on a particular date within a particular time period, that is consideration for your consideration, which is 30,000 rupees. So Amazon's consideration is executory, your consideration is executed. If you're a businessman in commercial transactions, most types of consideration in commercial transactions are executory in nature from behalf of one party. In commercial transactions, you deliver the goods purchased and then the purchase price is paid. In certain instances, you can have part performance, right? You can deliver, right? Or you pay, let us say, 50% of the purchase price in advance. You pay 50% upon delivery. Okay. So the consideration on both sides is still executory in nature. The moment they deliver the goods to you, basically, the seller, right, his consideration is executed. Your consideration of paying the purchase price or the remaining part of the purchase price is executory. And it's vice versa, or it's the facts are twisted in Amazon. You pay the money first, Amazon delivers the goods. Or if you've taken cash on delivery, what have you done? You have contracted with Amazon. You say, for your consideration of delivering a smartphone to me on May 1st, upon delivery of the smartphone, I shall pay cash on delivery to your delivery person, basically. Delivery boy or delivery girl, delivery person. Okay. So, their half of the bargain, their consideration stands executed the moment he stands at your door and he hands over the smartphone to you. Your consideration is executory, you have to hand over money. When there is past consideration involved, there is no question of executory consideration, because on one party, the consideration stands executed. The difference between past and executed consideration is simply this. Okay, all executed consideration basically does not necessarily have to have been done, okay, at the request or at the desire of the promisor simultaneously, basically. So there is no simultaneous execution. Okay, there is no simultaneous execution. So if we go into a shop and you want to buy a smartphone, you give him 30,000 in cash, he gives you the phone. The consideration on both sides is executed almost simultaneously, right? There's a quid pro quo, there is an exchange. That's not the case when you order the phone. That's not the case when Arjun goes to the BCCI and says, if you pick me in the under-19 team, I will call off negotiations. They pick him, their consideration, BCCI's consideration is executed. He calls off negotiations, his consideration is executed. Now, what about past consideration in this analogy? The past consideration arises basically in a situation where the act has been completed before there has been consideration on part of the promisor. So, Arjun says, BCCI, pick me in the under-19 team. BCCI says, okay, we'll pick you. Is there any benefit or detriment there to either party? Yes, there is a benefit to Arjun, but there is no benefit or detriment to the BCCI. Is there? You could say, yes, sir, Arjun is playing for India, that's a benefit to them. But there is nothing compelling them to pick Arjun in the under-19 team. So if Arjun goes to BCCI and says, pick me in the under-19 team, BCCI says, take a walk, Arjun cannot sue them for breach of contract because it's a mere nudum pactum. If BCCI says, okay, we'll pick you, it's a mere nudum pactum. The consideration comes in when Arjun, to his detriment, has called off negotiations with the ECB. Now, Arjun has gone again to the BCCI and picked me in the under-19 team. BCCI says, okay, we'll pick you. Okay. Arjun goes back for a few days and then the squad is announced. Arjun is in the team. Arjun comes back to the BCCI and says, now that you have picked me in the team, I will call off negotiations with the ECB. Is Arjun's promise to call off negotiations with the ECB supported by consideration from the BCCI's end? The answer is yes. The BCCI's consideration is past and it is executed. It is both past and executed. So I'm going to reread this judgment again of Dinbai. It's on your screen. Something which the promisee has done at the desire of the promisor before the promise is given is good consideration, therefore. It is therefore not necessary to consider whether the time that something was done by the promisee at the desire of the promisor, it was intended that recompense was to be given. Okay, right? Not necessary to consider whether at the time that something was done by the promisee at the desire of the promisor, it was intended that recompense was to be given. Pause. I'm back on screen now. This is the situation basically. There was no expectation on the part of the BCCI there that Arjun would do something in return for them picking him in the under-19 team. Pollock and Mullah say that's irrelevant. That's not a relevant consideration. What we need to see is if this promise by Arjun subsequently to call off negotiations is supported by past consideration, and yes it is, that past consideration being the act of BCCI picking him in the under-19 team. Let's go back to the judgment. Okay, so it is not necessary to consider whether the time that something was done by the promisee at the desire of the promisor, it was intended that recompense was to be given, the amount to be fixed at a future date. Although as stated in Pollock in Mullah 4th edition, in many common circumstances, the fact of service being rendered on the request is ample evidence of an undertaking that it was to be paid for according to the usual course. So it's a lot easier to prove that past consideration is good consideration in commercial transactions or in transactions involving money. It's a lot harder to prove in the Arjun BCCI analogy because there is no exchange of money, but there is an exchange of benefits on both sides, or a detriment. There can be no difference whether A says to B, I will give you 1,000 a month if you live with me for a year, or I will give you rupees 1,200 because you have lived with me for a year. The something to be done by the promisee in the one case is the same as something to be done in the other case. Therefore, I'm back on screen. The act of the BCCI picking Arjun for the under-19 team on the basis of his consideration that he will call off the negotiations is the same as the situation wherein the BCCI has already picked him. He then comes to him after he has been picked and says that I will call off negotiations with the ECB because you have picked me, basically. Okay, Arjun did not have a cause of action against the BCCI for not picking him in the first instance because it was a mere nudum pactum, a bare promise. But the BCCI will have a cause of action against Arjun for breach of contract because after they have given past consideration, after they have executed their consideration, he comes to them and makes a promise that he will call off negotiations with the ECB and indicates clearly that he will call off negotiations on the basis that he has been picked in the under-19 team. That consideration is past, but nevertheless good consideration. I'd like to deal with section 25, which look at the exceptions to the consideration requirement. Why, sir, are you jumping to section 25? Because there are situations where consideration is not required and an agreement without consideration is held to be valid, enforceable by law. When and what are those situations? They're set out in section 25. I'm going to deal with one subsection and I'm going to come back to the other subsections during the course of these lectures. Agreement without consideration void unless it is a promise to compensate for something done. Okay, something done. What is that done? An agreement made without consideration is void unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor or something which the promisor was legally compellable to do. So what has the BCCI done? They did something voluntarily for Arjun the promisor, didn't they? Or something which the promisor was legally compellable to do not need consideration. Look at the illustrations. They're very simple. Okay, and it will help you understand section 25. A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. It's as good as BCCI selecting Arjun voluntarily in the under-19 team, him coming to them and saying, hey, now that you've picked me in the under-19 team, I'll call off negotiations with the ECB. Don't do it. If you don't want to reward a guy who finds your purse, don't tell him I'll give you 50 rupees because once you do that, it's a binding contract. Okay, and you have all issues of bailment and the rights of finder of goods and all of that come into it, and that's a mess which we'll cover in part 2. A supports B's infant son. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract, basically. Okay, therefore, ladies and gentlemen, next slide. Past executed and executory consideration distinguished. I've already alluded to this, but let's go through it once more. And this difference between past executed and executory consideration, right, comes through in the illustrations. It is necessary to appreciate clearly the distinction between the two classes of contracts where the consideration is either executed or executory. An executed consideration consists of an act for a promise. It is the act which forms the consideration. Okay. No contract is formed unless and until the act is performed. Example, the payment for a railway ticket. But the act stipulated for exhausts the consideration so that any subsequent promise without further consideration is merely a nudum pactum. In an executed consideration, the liability is outstanding on one side only. It is a present as opposed to a future consideration. In an executory consideration, the liability is outstanding on both sides. It is in fact a promise for a promise. One promise is bought by the other. Pause it, read it carefully. I want to complete this judgment by Justice Sudhir Ranjan Das. Fabulous judgment. The contract is concluded, okay, and this is Union of India versus Chaman Lal Nuna. The contract is concluded as soon as the promises are exchanged. In mercantile contracts, this executory consideration is by far the most common variety, as I've told you. In other words, a contract becomes binding on the exchange of valid promises. Okay, a contract becomes binding on the exchange of valid promises, one being the consideration for the other. It is clear, therefore, that there is nothing to prevent one of the parties from carrying out his promise at once, i.e. performing his part of the contract, whereas the other party who provides the consideration for the act or detriment to the first may not carry out his part of the bargain simultaneously with the first party. Guys, I'm back on screen just to wrap up on this past executed and executory consideration. Section 25 says there are agreements that are enforceable without consideration. One such instance is where something has been done voluntarily at the instance of the promisor, or something that has been done voluntarily at the instance of the promisor, that it's so voluntarily done. BCI picks him in the under 19 team. Arjun says, hey, pick me in the under 19 team. They voluntarily pick him in the under 19 team. After the squad is announced, Arjun comes and says, what? You just say it with me. Okay, you've picked me in the under 19 team. Now I'm going to call off negotiations with the ECB. So therefore, in that scenario, what is the consideration? Executed on part of the BCCI, executory on part of Arjun because he has to call off negotiations. So is that a case of one promise being brought for the promise, of one promise being bought for another promise? Yes, it is. It just so happens that the act of the BCCI, right, was carried out before the offer of that promise was made. Okay, that's past consideration. Basically, all past consideration is executed. Past consideration can never be executory. Executory consideration can never be past. Okay, it's as simple as that. Okay, so when you have done something voluntarily at the instance of the promisor, or you have done something that you are legally compellable to do. So you say, sir, what are you legally compellable to do for free? Treat a patient. Treat a patient. Today we have Supreme Court case holding. They have declared that to be the law of the land, that a private hospital cannot refuse to treat a victim of an emergency, an accident. Yeah. So I'm from Bangalore, Manipal Hospital, for example, a hospital I know well. You have an accident on Old Airport Road, we call it in Bangalore, and the hospital is on Old Airport Road. They rush him to the hospital. They see this man and they see his clothes and say, hey, he's a vagabond, or he's a homeless person, he's a vagrant, sorry, right? This is a vagrant, he's not going to be able to afford the services of this hospital. Supreme Court says, no, you have to treat him. So what did they do? They were legally compellable to treat him. They were legally compellable to treat him. Once they have treated him, can they proceed against that person? Can they proceed against that person under Section 25? Yes, they can. Yes, they can. Although there was no consideration, it was an act done, right, under the directions of the Supreme Court. Therefore, the hospital was legally compellable to treat that person. And because they were legally compellable to do that voluntary act, well, it was not voluntary in the sense that they had no option. The Supreme Court has said, made it involuntary basically. So if they voluntarily treat him at his request, or they are legally compellable to treat him, even though there is no consideration, the act has been completed, but that act was not induced by a promise. It was induced by them having to do it legally. Then they can proceed. They can proceed against the person whose life they have saved, the victim of the accident, to recover their arrears, to recover their dues. And this happens all across the world, especially in places like England, in the United Kingdom, where you have the National Health Service that will treat you for free. But if you do not have NHS cover, which tourists don't have, then they will proceed against you. And in most cases, they will proceed against your insurer, which is why travel insurance is so important, basically. Okay, so don't confuse the law in England and India. The law in India is agreement without consideration is void. That's the general rule. Exception is when something was voluntarily done at the instance of the promisor. Let's put that back on the screen, right? Something that was voluntarily done at the instance of the promisor, basically, or something which the promisor was legally compellable to do, basically. Okay, therefore, A finds B's purse, gives it to him. B promises to give A 50 contract. A supports B's infant son. Often happens. Fathers who don't raise their children, they say, okay, let's say they get divorced, and they say, okay, you raise my son and I will pay you his expenses. Forget about the family law requirements. Okay, let's say that they're not married. Okay, let's say that, forget about equity and all that. He says, okay, you raise my son and I'll pay his expenses. Okay, that is a contract. It's as simple as that. Judgment of Justice Sudhiranjan Das, which I've already discussed, right, beautifully illustrates, Union of India versus Chamanlal Nuna, beautifully illustrates this difference between executed consideration. Okay, so The question, therefore, ladies and gentlemen, the big question, and that slide is on your screen now, is does consideration need to be of value? Does consideration need to be of value? Does consideration need to be adequate? What are the answers to the question? Well, let's look at the case of Kulasekara Perumal versus Pathakutti Talavanar, 1960 Madras High Court. In English law, the term consideration bears the meaning given to it in the classical judgment of Curry and Misa. Okay, and what did the court say there? It's the Court of Exchequer. A valuable consideration in the sense of the law may consist either in some right, interest or profit or benefit accruing to the one party, or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. We know this. Though the Indian Contract Act does not in terms provide that consideration must be good or valuable to sustain a contract, it has always been understood, says Justice Jagdishan of the Madras High Court, it has always been understood that consideration means something which is of some value in the eye of the law. It must be real and not illusory, whether adequate or not, adequacy being a matter purely for the contracting parties to decide and agree upon. So long as the consideration is not unreal, it is sufficient if it be of slight value only. So adequacy, ladies and gentlemen, adequacy is not necessary. It must be consideration of some value. Okay, I'm back on screen. So the courts may very well say, when I take my father to court, they say, okay, so your father agreed to cook dinner and he said he would cook you dinner if you first cleaned the car. You cleaned the car, he didn't cook you dinner that night, and now you have filed a suit, okay, and you have placed a plaint before this court saying that you want to sue him for breach of contract. Yes, sir, you say to the judge. Yes, your honor, you say to the judge. That says, but this consideration is not real, it's illusory. It's a very illusory consideration. Really, it's up to the individual judge. You say, hey, Judge Saab, mujhe, khana bahut pasand hai. I like my father's cooking a lot. That consideration is of value to me. And my father loves the car. He loves keeping the car clean. That consideration is of value to him. The judge says, but that's not adequate for there to be a binding contract. You should respond to the judge through your pleader. Your honor, consideration need not be adequate. Consideration only need have value in the eyes of the parties, right? And in the eyes of the law, basically. The consideration must have value in the eyes of the law. Okay, let's go back to the slide. It's on your screen. What does Justice Jagdishan say? What are the tests for determining consideration that is valuable? In order to test whether a consideration provided for is real or not, the following tests have been laid down by Anson, again a leading textbook writer, Anson in his Law of Contract. Did the promisee do, forbear, suffer, or promise anything in respect to the promise to him? Was his act, forbearance, sufferance, or promise of any ascertainable value? Was it more than he was already legally bound to do, forbear, or suffer? On the answer to these questions depends the reality of the consideration. You need to reproduce these 3 bullet points, basically, these 3 considerations. I'm going to read it again, so important. Please reproduce in your exam. Did the promisee do, forbear, suffer, or promise anything in respect to the promise to him? Yes. I washed the car. Was his act, forbearance, sufferance, or promise of any ascertainable value? Yeah. Maybe not monetary value, but certainly a value to my father. He loves his car. Okay. Was it more than he was already legally bound to do, forbear, or suffer? I'm not legally bound to clean the car. Okay, I'm not legally bound to clean the car. And then my father might say, I'm not legally bound to cook him dinner. Sure, you're not legally bound to cook him dinner. So what is the situation? There is value. There is valuable consideration in a case like that, basically. And remember, it has to be something which has value in the eyes of the law. Eyes of the law. There cannot be any doubt that, and this is the facts of that particular case, okay, that Justice Jagdishan is looking at. There cannot be any doubt that the deed of conveyance in this case was not a mere gratuitous transfer by Subbaiah in favor of his wife. In consideration of her enjoying the properties, she was not merely made liable to pay a few of the debts which Subbaiah had incurred, but she also undertook the burden of a maintenance charge and to pay maintenance to Subbaiah's mother. The transferee under the deed of conveyance could not have accepted the gift of the properties without the burden imposed upon them. I am of the opinion, therefore, that the deed of conveyance is an alienation for value. I am of the opinion that it is an alienation for value. Okay, ladies and gents, therefore, okay, and I'm back on screen, very simply put, in many instances, when a father will convey property, title to a property to his son, and in return for conveying that title to property, the son undertakes to pay maintenance, the son undertakes to take care of the mother and the father. The son says that every month we will give you 5,000 rupees and out of the proceeds from you conveying the property to us, for your consideration of conveying the property to us. That's not a gift. It may be on the face of it, the deed of conveyance may be on the face of it a gift, but looking at the substance of the document, like Justice Jagdishan did in the case of Kulasekara Perumal, he will say that this is an alienation for value. Sir, what is alienation? Come on, go look at my property law lectures part 1. I've explained alienation in detail over there. Alienation, a sale of property, is an alienation of the property. Conveying title is an alienation of property. Therefore, he says, you might call this a gift deed, but this is an alienation for value. And this often happens. If you've seen, there's this Marathi film by Nana Patekar, and it's being made into a film in various languages. It's called Nata Samrat. So in this movie Nata Samrat, what does Nana Patekar do? The fool that he is, basically, he conveys all his properties. He has, I think, one house. He conveys it to his children. Why does he do that? Of course, the children are going to take care of him. I don't want to spoil the movie for you, but there's not really much of a suspense. But they do throw him out of the house, and the whole movie is about how he deals with it. But if Nana Patekar had gone to court, basically, you can see in the dialogue and the exchange and the discussions that take place between Nana Patekar and his children, there is clearly, right, consideration given on behalf of the children, saying I think it's the son says, I will take care of you, hum aapka dekhbhal karenge, etc., etc., and he conveys the property. So in the future, if you're ever conveying property to your children, all right, it's very, very important that you enter into a very detailed agreement. Basically, you can call it a settlement deed, call it what you want, but make sure a document is executed clearly laying out what it is that they undertake to do for you, your upkeep, your well-being, right, in return for title to the property being conveyed to them. So even if you execute a gift deed, courts have repeatedly read into them terms, or not read into them, or interpreted terms therein to mean that actually this is not a gift deed but an alienation for value. Alienation for value, alienation for value, the word there is value. Therefore, again, consideration must have value, right? Taking care of them in their old age has value. It might not be ascertainable in monetary terms, it could be, okay, but it has value. It's an alienation for value. And in that case of Kulasekara Perumal, what happened, basically, there was Subbaya transferred title to the property, right, basically, and the transferee undertook to pay Subbaya's wife X amount of money for the upkeep and all of that. So it was not a gift, it was an alienation of value. And when there's an alienation for value, what do you have? You have a contract. And what do you have when you have a contract? You have consideration, right? Consideration for value. And once you have consideration, you have an agreement. Once you have an agreement, it's an agreement. Then you have to make sure the agreement is enforceable by law. When does an agreement become enforceable by law? As long as it is not enforceable by law. So what are the situations in which an agreement is not enforceable by law? We're going to be dealing with that in the next couple of lectures, such as coercion, undue influence, misrepresentation, fraud, mistake, and what have you. Okay, so it's a beautiful logical piece of legislation. Basically, the course is very sequential. Okay, it's one after the other, easy to understand. Now, before I move on to the next lecture, I still have about 10-15 minutes left here. I would like to deal with another section of section 25, and that section, it's on your screen now, right? It's the explanation, basically, and I'm quoting here from a case. I'm quoting from the case of Devji Shivji versus Karsandas Ramji, Patna High Court, 65 years ago. And I'm looking here at the explanation to section 25. Explanation 1 of the section says that nothing in the section shall affect the validity as between the donor and donee of any gift actually made. Aha, there we go. So the law relating to gifts, okay, basically, right, the validity of a gift does not get affected, right, by section 25. What does that mean? Basically, guys, I'm quickly back on screen. All gifts are agreements made, I beg your pardon, all gifts are conveyances made without consideration, obviously, right? That's why it's a gift. So section 25 says an agreement without consideration is void. So it is important for the explanation to reiterate that although a conveyance deed, basically, okay, or an agreement to convey a particular property from a father to his daughter out of love and affection, we're coming to those words shortly, can be is an agreement without consideration. It does not become void because it's a gift. Father is the donor, daughter is the donee, so it does not affect gifts made between donor and donee. But as we've seen, if it is an alienation for value, it becomes a contract. It's not a gift, It's an alienation for value, and there the rights arising therefore out of that alienation for value are contractual in nature. Let's go back to that case. It's on your screen. So explanation 1 says nothing in this section saying that an agreement will be void if it is not supported by consideration shall affect the validity as between the donor and donee of any gift actually made. Explanation 2, and this is important, an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given. Okay, now we are dealing with a completely different issue, basically. Okay, so an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. Therefore, I'm back on screen. Someone might turn around tomorrow and say, Your Honor, I have agreed to sell this house for 10 crores. The value of this house is 100 crores. My consent was obtained by fraud. My consent was obtained by undue influence. My consent was obtained by misrepresentation, what have you. So basically he could say, Your Honor, I transferred this land to the local goon, the land grabber, the mafia, the local don. Basically he put a gun to my head and said, sign this agreement of sale, convey this house to me for 10 crores, take your 10 crores and walk away, all despite the fact that the house is worth 100 crores. Therefore, in a scenario like that, what does explanation 2 to section 25 say? It says that, look, the adequacy of the consideration can never be a factor when determining whether that consideration has value. So even if a house has been transferred for 1 rupee, we will look at the non-monetary aspects therein to see if that consideration has value, but we will not prima facie say, oh, how can you transfer a house for 1 rupee, basically. Okay, again, forget about the tax authorities. A transaction like that is clearly an attempt to hoodwink, right? The tax authorities. You have to pay stamp duty when you transfer a title in a immovable property. Okay, so that's an attempt to evade stamp duty. It could be an attempt to evade capital gains tax. You have to pay capital gains tax when you sell immovable property. So your tax authorities, like I said, will be up your backside, but let's keep that aside. So let's take more realistic figures. 10 crore house you have sold. 100 crore house you have sold for 10 crores. What the court will say is, look, we are not going to say that this consideration is inadequate. We are not going to say the consideration is inadequate. What we are going to do is we are going to look at the amount of consideration to determine whether the consent to this contract was freely given. We're not going to say, oh, you know what, of course this consent was not freely given because it's been sold only for 10 crores. It's a factor to consider when the plaintiff comes to the court and he says, I sold a 100 crore house for 10 crores. The reason I did this was I was under undue influence, basically, or there was duress. Yeah, there was coercion. We call duress coercion in this country. Okay, there was a gun to my head. Literally, metaphorically, there was a gun to my head. He said, you don't transfer this, I'm going to come and kill all your family members. The local don, basically. Okay, so they will take the adequacy of the consideration into account when determining whether consent was freely given, but merely the inadequacy of the consideration cannot be a factor to say that the agreement is not enforceable by law. I hope that's clear. It's always about the value that the consideration has. It's a 100 crore house, but it is sold for 10 crores. The defendant proves in court that the plaintiff sold the house to him for 10 crores because he had an outstanding liability of 10 crores. He had been diagnosed with cancer. He had 6 months, the doctors had given him 6 months to live. Therefore, he said, I want to pay off my debt of 10 crores. Ergo, I want to sell my house for 10 crores. If he can prove to the court that these are the circumstances under which he sold the house, and these are the circumstances under which he sold the house well below the circle rate. What is circle rate? Go and watch my lectures on capital gains in income tax. You'll understand. Circle rate is a rate set for that particular locality by the government. Okay, basically. So what happens in a situation like that? The court is convinced. They say, yes, we will look into the inadequacy of the consideration to determine whether consent was freely given. Okay, tomorrow what could happen, and this has happened in several cases, you have somebody who will sell a house for 10 crores even if it's worth 100 crores because he has a debt of 10 crores. Then he will turn around and say, oh, in fact, you know, my consent to the sale was obtained by coercion. That's why I sold it for 10 crores. He wants to have his cake and eat it too. Basically, courts will not allow that. Okay, that is what explanation 2 to section 25 seeks to strike at. We look at the adequacy in determining whether consent to the contract was freely given. Let's go back. Okay, There are two illustrations given in the section which must be referred to in this connection, and they are illustrations F and G to section 25. Go please read the entirety of section 25. I've covered it in bits and pieces here. A agrees to sell a horse worth 1000 rupees for 10 rupees. Same analogy. A's consent to the agreement was freely given. The agreement is a contract notwithstanding the inadequacy of the consideration. There we go. 10 crore house, right? Sells the house for 10 crores, house worth 100 crores, but he has a debt he needs to clear for 10 crores. Consent freely given, inadequacy not a factor. A agrees to sell a horse worth 1000 for 10 rupees. A denies that his consent to the agreement was freely given. The inadequacy of the consideration is a fact which the court should take into account in considering whether or not A's consent was freely given. Okay guys, and now I'm going to continue with this fabulous judgment by Justice Narayan of the Patna High Court. He looks at agreements, okay, made on account of love and affection. It's on your screen. According to section 25 Contract Act, this is another consideration. Where an agreement is made on account of love and affection, it is expressed in writing and is registered under the law for the time being in force, right? Then the lack of consideration does not make the agreement void. Okay, so according to section 25 Contract Act, an agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between the parties standing in a near relation to each other, I beg your pardon. The position in this case is that the agreement is made on account of natural love and affection, and that is a factor which has to be considered in considering the allegation of the plaintiff that the document was intended to be a Benami document. So this happens a lot, Benami transactions, right guys? He says the position in this case is that the agreement is made on account of natural love and affection, and that is a factor which has to be considered in considering the allegation of the plaintiff that the document was intended to be a Benami document. The plaintiff in this case has not alleged any undue influence or pressure as against the defendant, his statement being that for the facility in carrying out on the business, he executed the document. His consent to the agreement must therefore be deemed to have been freely given, and the agreement is a contract notwithstanding the inadequacy of the consideration. There is no question of a fraud on any third party in this case. If fraud is meditated, and if the necessary effect of a transfer founded even on natural love and affection is to perpetrate a fraud, I beg your pardon, on a third party, such a transfer may not be regarded as a transfer in good faith and a transfer for value. Okay, so it's not a transfer for value. Guys, back on screen, what happened in that case? Basically, a father-in-law transferred ownership in the business to his son-in-law. The consideration was quote unquote inadequate. The court said that's immaterial. The father-in-law was of old age. Basically, he transferred the business to the son-in-law. That's it. Yes, there was, arre dal mein kuch kala hai. Always there is something that is a little murky in these transactions, but they said nothing has been pleaded, no fraud has been alleged by the father-in-law. He is not saying that the contract was vitiated by any of these considerations of fraud or undue influence or misrepresentation or coercion, gun to your head. So in that scenario, clearly it's his son-in-law, clearly it's an agreement, yes, without consideration, but it is an agreement that is made in writing and it has been registered, right, in accordance with the law for the time being in force for the registration of such documents. The conveyance is not basically one for value. It's a conveyance that is in good faith, and despite there being no consideration, this conveyance is saved by section 25 basically. Okay, so there's no question of inadequacy, it's always about the value of the consideration. And guys, long lecture coming up on almost 90 minutes. To wrap up, I have 2 slides left, and this is something I alluded to in our previous lecture, the case of Lalman Shukla versus Gauri Datta. Remember that case where a munim of a firm is dispatched by his master, his employer, the proprietor of the firm, to go to Haridwar because the son of the proprietor is missing. He says, go to Haridwar, find my boy. He's a munim. He goes there, starts looking for the boy. Then it comes to his knowledge that a reward has been offered for finding the boy. Certain handbills, you know, handbills are, have you seen my dog? Remember I told you this man is wanted, that's a handbill. Information on this, you will get 100 rupees or 200 rupees or whatever. So a reward was offered, a big amount was offered for finding this boy. He comes to the knowledge that this reward has been offered. In any event, these handbills are sent to him when he's in Haridwar looking for the boy. He finds the boy. He then comes to the court and says that I should now be given the reward for finding the boy. Is there consideration? Is that a case of past consideration? Now you see the past consideration. Is that a case of past consideration? Basically, that he set out to look for the boy. Okay, he set out to look for the boy. He hasn't found the boy. Okay, as he has set out to look for the boy, these handbills have been sent to Haridwar saying reward of so much for finding the boy. He finds the boy, and he can then claim the reward because when he set out to Haridwar, he went in his capacity as the munim of the firm. He didn't go as somebody who was going to Haridwar on the basis of the promise of that reward. So there are several things that Lalman Shukla Gauri Datta's short little judgment, okay, but encapsulates so many different areas of contracts. Consideration, privity of contract, then the pre-existing duty rule, past consideration, it covers all of this. So let's go to that case now, and we'll now look at that case in a different light, basically, from when we looked at it in the context in the earlier lecture where we said, how could he have accepted the offer of the reward, okay, when he set out to look for the boy, when he had no knowledge of the offer? And what did I tell you? The court chose not to decide the case on that issue. They said, when you have no knowledge of the offer, you cannot accept. But yes, here he comes to the knowledge of the offer, right? He has knowledge of the offer when he reaches Haridwar and the handbills are sent to him and he has not yet found the boy. So yes, he has knowledge of the offer, but the court said no. He set out from Haridwar under his duty. He had what is known as a pre-existing duty, and this is known as the pre-existing duty rule. It's on your screen now. Okay, so consideration and the pre-existing duty rule. The facts, okay, are these. In January last, the nephew of the defendant absconded from home and no trace of him was found. The defendant sent his servants to different places in search of the boy, and among these servants was the plaintiff, who was the munim of his firm, basically. He was sent to Haridwar and money was given to him for his railway fare. Yeah, money was given to him for his railway fare and other expenses. After this, the defendant issued handbills, a small printed advertisement or other notice distributed by hand, offering a rupees 150 reward, 150 rupees, more than 100 years ago, a big sum of money, to anyone who might find out the boy. The plaintiff traced the boy to Rishikesh and found him there. Defendant contends that the plaintiff can claim, the plaintiff's claim can only be maintained on the basis of a contract, that there must have been an acceptance of the offer and an assent to it, that there was no contract between the parties in this case, and that in any case the plaintiff was already under an obligation to do what he did and was therefore not entitled to recover. On the other hand, it is contended on behalf of the plaintiff that a privity of contract was unnecessary and neither motive nor knowledge was essential. What did we say? Motive not important, knowledge is essential. The finding in that case was you need to have knowledge of the offer, but that did not form part of the ratio of the case. What formed part of the ratio of the case, right, was that the munim was, and it's on your screen, performing pre-existing obligations. The court below, and this is the Allahabad High Court Justice Banerjee, the court below having dismissed the claim, this application for revision has been made by the plaintiff. Civil revision, go see my CPC lectures, and it is claimed on his behalf that as he traced out the boy, he is entitled to the reward offered by the defendant. In the present case, and this is important, the claim cannot be regarded as one on the basis of contract. The plaintiff was in the service of the defendant. As such servant, he was sent to search for the missing boy. It is true that it was not within the ordinary scope of his duties as a munim to search for a missing relative of his master, but he agreed to go to Haridwar in search of the boy. He agreed to make that one of his duties, okay, in search of the boy, and he undertook that particular duty, being under that obligation which he had incurred before the reward in question was offered. He cannot, in my opinion, claim the reward. There was already a subsisting obligation, and therefore the performance of the act cannot be regarded as a consideration of the defendant's promises. So when there is a pre-existing obligation, a mere performance of your pre-existing obligation cannot form consideration. For the above reasons, we hold that the decision of the court below is right, and I dismiss the application with cause, is what Justice Banerjee said. Okay, so basically, what is it? There is no fresh consideration. I'm back on screen. There's no fresh consideration in this case. The Allahabad High Court held. And to wrap up this lecture, I'm going to give you a classic example. Kulbhushan Yadav. Okay, Kulbhushan Yadav says he's a businessman. Let's assume he's an Indian spy. Kulbhushan Yadav basically is in Pakistan. Okay, now he's held in Pakistan. Okay, I think they arrested him somewhere in Iran. Let us say Kulbhushan Yadav crosses into Pakistan. Kulbhushan Yadav spots Dawood Ibrahim. Kulbhushan Yadav then calls up a hotline. Okay, there is a Government of India hotline that offers so many lakhs of rupees for anybody who can offer valuable information on India's most wanted Dawood Ibrahim. Kulbhushan calls up the hotline and says, here is my information on Dawood Ibrahim. Hotline says, thank you very much. They have the information. Kulbhushan Yadav then says, where is my reward? Can Kulbhushan Yadav be given a reward? Assuming Kulbhushan Yadav was an employee of RAW, the Research and Analysis Wing, India's spy agency, Kulbhushan Yadav had a pre-existing duty to essentially scout where Dawood was and to provide information on Dawood's whereabouts to the Government of India, to his nodal agency, which is RAW, basically. So he had a pre-existing duty to provide information on Dawood Ibrahim as an employee of the Government of India. It was part of his scope of duties. And in fact, when he went to Iran, right, or when he went to Pakistan or wherever he is, the details are very sketchy about how he exactly ended up in Pakistan. Assuming he was our spy in Pakistan, in that scenario, he had a pre-existing obligation to provide valuable information about Dawood. And simply upon providing that obligation, that information to a hotline, he cannot now claim the reward. So pre-existing obligations, the performance of pre-existing obligations, usually by a servant or an employee, can never form consideration. And such a claim can never arise on the basis of a contract. And ladies and gentlemen, I promise you, that is the end of this lecture, right? And that is a promise that is unsupported by consideration, right? That is the end of the lecture on consideration. It's a very tricky topic, okay? And I really suggest that you rewatch this lecture if you can, right? The full 80-90 minutes of it, because you were guaranteed to get a very, very important question on this in your exams. It'll be a big chunk of your exam. And if you understand consideration, you understand contracts.